5, 4, 3, 2, 1, start. The only question involved in this appeal for consideration by the court is whether the jurisdiction of the civil court is barred under section 145 of the Indian Electricity Act in the cases where the demand of the electricity board is of the charges based on alleged theft covered under section 135 of the Electricity Act, and further whether the consumer can be suggested and alternate remedy of appeal under section 127 of the Act, full stop. The facts of this case are that the respondent herein had filed a suit for permanent and mandatory injunction to the effect that defendants be restrained from disconnecting the electricity supply of the meter installed in the premises, and they be also restrained from recovering the impugned penalty of rupees 1 lakh which was imposed by defendant number 1, full stop. It was pleaded by the plaintiff oblique respondent herein that he was having a domestic electricity connection of Atta Chakki in his premises at village Khedi, Tehsil and district Rohtak since 1981, full stop, stanza. On 14 January 2005, the above said electric meter got fire due to some electric fault oblique voltage fluctuation and the meter was burnt, full stop. The plaintiff's neighbor Ramlal had seen the burning of the meter and informed the plaintiff about the same, full stop. Number of persons from neighborhood, even the sarpanch and panches of the village also gathered there, full stop. The plaintiff went to inform the lineman of the area along with his uncle to village Kalera, full stop. But the lineman was not available, and then another lineman came to the village and he inspected the site and asked the plaintiff to report the meter to the JE of the area, full stop. Thereafter, the matter was reported to the said JE, full stop. On 15/1/2005 in the morning, the JE had come and inspected the site and an application in writing was given on the same day which was entered in the complaint registered of the defendants, full stop, stanza. Thereafter, the defendants asked the plaintiff to purchase a new meter and the new meter was purchased through a mediator tea vendor who was having a tea stall outside the office of the defendants, full stop. An amount of rupees 1000 was charged from him and the new meter was sent to the laboratory for testing the same on 16 January 2005 itself, full stop. It was further pleaded in the plaint that Rakesh Kumar JE told the plaintiff that his connection was operating an Atta Chakki and therefore the SDO is demanding rupees 25,000 from the plaintiff, and that if payment is not made by him to them, then a case for theft of electricity would be registered against him, full stop. The plaintiff requested the above said SDO that he was not at fault when meter had been burnt, full stop. It was further pleaded that the above said B. N. Dhakad came to the village on 18 January 2005, threatened the and demanded rupees 23,000 from the plaintiff, full stop, stanza. Plaintiff became terrified and paid rupees 10,500 to JE, full stop. On 18 January 2005, in the presence of the Vikram and Surender, after taking rupees 10,500, JE asked the plaintiff to visit Rohtak office on 25 January 2005, and there the signature of the plaintiff was obtained on some printed papers, full stop. Thereafter, JE threatened that if the balance of rupees 10,500 is not paid, then he would be helpless, as the above said persons were demanding the full amount of bribe, full stop. The plaintiff expressed his inability to make more payment, full stop. Thereafter, a false report was prepared by the officials that M and P seal of meter were found missing and rivets found tempered, full stop, stanza. It was claimed by the plaintiff that neither meter was tampered nor seal was tampered by him. Full stop. The meter was burnt out due to the electricity supply voltage fluctuation. Full stop. On 27 January 2005, the plaintiff received a letter dated 26 January 2005 by which the penalty of rupees 1 lakh had been imposed. Full stop. It was further pleaded that challenging this illegal demand, the plaintiff had moved the District Consumer Dispute Redressal Forum Hisar bracket start for short the forum bracket close full stop. The forum held the deficiency in service and negligence on the part of the defendants, and the complaints were accepted, and the checking report dated 18/1/2005 and the notice regarding penalty dated 26/1/2005 were quashed, and the defendants were directed to restore the electricity supply of the Atta Chakki in the premises of the plaintiff. Full stop. Stanza. However, on appeal, the State Consumer Commission held that the plaintiff does not fall in definition of a consumer. Therefore, the order passed by the forum was reversed. Full stop. Resultantly, the plaintiff had to come in civil suit challenging the illegal order of penalty and also seeking injunction against disconnection of the electricity supply. Full stop. In the meantime, a case of theft of electricity was registered against the plaintiff vide FIR number 29/2005 at police station Sadar Hisar. Full stop. The plaintiff was granted anticipatory bail in the case. Full stop. Thereafter, the plaintiff had also filed a criminal complaint against the above said JE on 7 April 2005. Full stop. It is another thing that this complaint was later on dismissed by the court. Full stop. However, in the FIR case related to theft of electricity also, the plaintiff was acquitted by the criminal court. Full stop. Stanza. It was pleaded by the plaintiff in the suit that all the defendants in connivance with each other fabricated the story and the checking report dated 8 January 2005 and 21 January 2005 in order to pressurize the plaintiff to extort the money. Full stop. Otherwise, there had been no theft of electricity in this case. Full stop. The respondents filed written statement in the case. Full stop. It was alleged that the plaintiff was having a small category connection. Full stop. However, he was using it for commercial purposes. Full stop. It was further submitted in the written statement that plaintiff himself burned the meter only to remove the evidence of breaking of the seals of the meter by him. Full stop. Stanza. It was further claimed that the meter was checked on 18 January 2005 by Sri Sohan Lal AE after receiving information on telephone from an unknown person regarding the committing of theft of energy by the plaintiff. Full stop. The said premises was found logged on 18 January 2005. Full stop. After checking, the plaintiff moved an application in the office of SDO Operation Subdivision Adampur for changing the meter. Full stop. On 23 January 2005, the meter was got checked in the lab in the presence of the plaintiff. Full stop. During checking, all M and T seals of the meter were found missing, and both the rivets were found tampered, and meter block terminal of the meter was found burnt. Full stop. Hence, it was claimed to be a clear case of theft of electricity. Full stop. Stanza. It was further claimed that a notice for compounding the offence was served upon the plaintiff vide memo dated 26 January 2005 under sections 135 and 152 of the Indian Electricity Act, whereby the answering defendant required the plaintiff to deposit a sum of rupees 80,000 for the loss caused to the Nigam, and further required the plaintiff to deposit a sum of rupees 1 lakh for compounding the offence. Full stop. It was claimed that just to save his skin, the plaintiff was leveling mischievous allegations. Full stop. It was also claimed by the defendants appellants herein that the civil court has got no jurisdiction to try the suit full stop. Parties led their respective evidence full stop. After appreciating the evidence and hearing the parties, the trial court dismissed the suit full stop. Issue number 3, framed by the learned trial court, was regarding the jurisdiction to try and entertain the suit full stop.